an AO account? Is that the
Yes.
program that it's under, or is it under the
So
IPAC?
so those two are actually interrelated. So it depends on how and who you are contracting with. If you're contracting with governmental agency, it will be under both. If you're contracting with just private entity, it will be one of the other because they don't want you to have
Got it.
both accounts. But if I were you, what I would do is I would text her to make it an open account because what that would do is it will allow you portal access to both and you can open based on each agreement. So what that would allow you to also do is it would allow you to put different trusts under that same account. And remember, only one Express Trust account can go on each. So just have her open it up because once it's open up with that initial Express Trust of yours, you can now
Got it. And I'm assuming that those subsidiaries is when we'll introduce the 508.
yes. Or other
Got it.
Express Trust. For instance, if your child is a minor and you your child is yet to be able to do what you're doing, that still doesn't stop that child from having their own Express Trust. So in the meantime, you will do it no different. Always remember, you are the master of the suit. And in summary, a suit has three main parts. The first part is the jurisdiction and venue. Now, with the jurisdiction and venue, in some cases, you will see some people stylize it separately, where they say jurisdiction, they write, venue, they write. But me, I just put jurisdiction and venue because the reality is the venue is highly attached to the jurisdiction. The jurisdiction is the nature of law. Juris means law, diction means the language of things. So based on the language of law that you bring in will determine the court. And of course, each court have geographical bounds, which are venue. So ultimately, jurisdiction and venue are really tied together. So I just categorize it under this section as jurisdiction and venue, just being one. The second main portion of any suit are the parties. So this is where the public viewing the case or the acting judge looks at it and go, okay, these are the guys involved. And depending on the nature of party will determine things like statutes of limitation. So if you bring in tort and you're suing a certain type of party that is not a private entity, tort, when it comes to suing public entities like AKA municipalities or governmental entities, they will have to start looking at the scrutinies of statutes of limitation within the Tort Act of each state and the Tort Immunity Act of each state. So based on the party you're suing would determine how anyone can attack the suit. That's why it has its own section. Under this party would also be where you would establish minimum contact to show how the party is basically a subject to this suit. Minimum contact is tied to venue, and I'll be showing you that. And if the minimum contact is tied to venue, it by default ties to jurisdiction because jurisdiction and venue goes hand in hand. Again, juris means law, diction means the language. In other words, the language of the law. The language of the law. So for instance, if you're in the United States court, in order for you to evoke any type of federal law, you have to bring something called a federal question. Federal question is someone violated the United States Constitution. Because of that, there is jurisdiction. Now, within, say you're at Los Angeles. Within Los Angeles, there are different districts on the federal level for the federal courts. So whichever one is closest to you or the defendant, or whichever one is closest to the defendant or the location to which the tort took place or the damage took place, that's where the venue will be. And then the parties and the third are the facts. Here I like to put undisputed material fact. You always want to put this term undisputed because the assumption is that they are guilty by default. They always treat people with impunity of guilty before innocence, even though in North America, absence of Sharia law. Remember, North America has a mixture of type of legal systems, and Sharia law is one of those. But commonly speaking, they like to use the Christian version. And in the Christian version, in the New Testament, not the Old Testament, they use the New Testament. That's where the concept of innocent before guilt comes from. But they only use that to their benefit when they're coming at you. They use the Old Testament, which is guilty, and you have to prove yourself innocent. Well, you use the same foundational Old Testament because that really have more power. When it's undisputable, that means they have the burden of proof. The moment you use certain words, aka jurisdiction, the jurisdiction is based on the words you use. Remember, diction is words. And within this the laws that you're going to be evoking will be in the counts, which is the fourth section. And based on the language of what you put here, the assumption based on how you labeled it. Okay, just making sure it hasn't kicked me out yet. The assumption is that based on how you labeled it, here, undisputed, everything else in here, which is the fact of the case, where you be saying, see material fact so-and-so, see exhibit so-and-so, is labeling them as though they're guilty. And when you do that, it forces them to speak up. Otherwise, they're in default. So the way that I structure this is I really don't put in anything relating to 28 USC, 26 USC or anything, because 28 USC is what governs the judicial on a federal level. So what I put is I just put this court has jurisdiction pursuant to United States Constitution and a harmonious laws preserving the rights therein against Carlo's law. Okay, give me a moment. The computer is lagging really bad. Let me restart the program that I used to record it, because that's what's causing the lag. So just give me a moment. Okay, good. So you asked, does everything spoken of here, let me share my screen. So you asked, does everything spoken of here, when it comes to all other claims, does it involve state claims? In short, yes, it does, because state claims are how tort claims are derived. So it covers state claims and everything else. Now, let me give you an example. Oh, go ahead. You got it. You got it. Let me give you an example. I was gonna go over this later, but since the question came up, we might as well go into it. I know some of you guys are. Go ahead.
Say that again. Aha. Yeah, so with that, so remember that was the video that I'm referring to. But with that, you can't, yes, that is the example that I'm referring to. So say a state law governs a bus and says that every time a bus stops, everyone must stop behind him because it has a stop sign. Now you cannot evoke that because it only applies to particular entities. But if it applies basically as a right that everyone ought to know, such as things that I mentioned earlier, like hate crime, defamation, intimidation, swindling, legal process, assault, battery, trade secret being one of them. So let me give you this example now. On a state level, some of you guys are at Pennsylvania, some of you guys are at Florida. So I'll show it to you. For instance, Florida has laws. Each state has laws based on trade secret. Trade secrets is under intellectual property. When you do that thing called copyright, let me change the screen that I'm sharing to show you this. One second. Okay. When you do this right here, can you see this screen with the copyright? Okay. When you do this and you say declaration of copyright for property so and so, and you put every proceeds fingerprint biometric data, this is copyright. Now, each state trade secret. Now the question is, are you seeing how it connects? Because you've evoked original jurisdiction. And original jurisdiction, go ahead. Yeah. Yeah, an original jurisdiction opens up jurisdiction for all other claims, and they shall entertain it. So just by you mentioning the United States Constitution, you've opened door to evoke trade secret. And the thing is, now that you know that tort is based on the language of the state claims, and you, on the other hand, in order for you to have the right to evoke trade secret, you've done copyright on it. So the purpose of you compilation, first, last, address, social security number, right. Program device, method, the counting method, same thing. Drawing, like your signature, your image. Your image, when they take your mugshot, that is classified under drawing. Process. Financial data. Here they use the term device and method. List or actual or potential customers or suppliers that is sufficiently secret to derive economic value. Meaning, unless you give it to them, they cannot derive value in it. Actual potential from not being generally known. And the only way that it can be generally known is if they violated the Constitution, to which you will have invoked as a source of your jurisdiction in the case earlier, which opens the path for supplemental jurisdiction, which is this. See how everything connects? To persons who can obtain economic value. So independently, it is sufficient secret to itself as a value. And then when they begin to use it and they know it, they have it has economic value that they can derive from it. In other words, monies. Now that you know what trade secret language is in your state, what will be the verbiage in your document? Well, let me show you how you will finagle it. You might have heard me say, well, it depends on how you finagle things. So remember, we're just still in the jurisdiction and venue part, and it's already taken us to the end. If you've ever noticed in a few videos earlier on in 2021 and 2022, I mentioned if you really want to comprehend how legalese work, start from the end, especially suits. Read the beginning and go straight to the end, because that's where the two glues are. Everything in between is just relating to the beginning and the end. So that one question that someone asked when it comes to what is the state of mind between this verbiage, all other claim, if you look at the supplemental jurisdiction, you realize that that verbiage, when it comes to all other claim, I took it directly, literally, from here, where it says, the district court shall have supplemental jurisdiction over all other claims that are related, so related to claim and the action within original jurisdiction, that they form part of the same case or controversy under Article 3 of the United States Constitution. This exact verbiage, I simply took it and simplified it and put the court has supplementary jurisdiction in all of the claims related to claims of original jurisdiction that form part of the same under Article 3 of the United States Constitution. That is the thinking. And part of that thinking, which now relates to and links to everything else you're going to be doing, will be one of the verbiage of trade secret. So now that you know that the all other claims relates to tort, aka derivative of state laws which you have privatized. So now you know these verbiage of probable cause is exactly what the Constitution speaks of. The requirement of Fourth Amendment speaks of the requirement of probable cause for your properties and persons to be searched. So you simply state that they simply violated, attach that to them, absent of the particularities on a tort level. And then related to any contract, if it's a contractual matter. That's how you basically evoke a separate count with the Constitution itself, separate from what relates to the Constitution as another count. Bold, can be anywhere. For the purpose of depriving, either directly or indirectly, any person or class of person of the equal protection of the laws. These laws, see how they made this very, very, very vague? These laws is whatever other counts that you break. That is why you can attach conspiracy to any of the counts. Protection of the laws or of equal privilege and immunities under the laws or for the purpose of preventing or hindering the constituted authorities of the state or territory from giving or securing to all persons within such state, territory, blah, 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 of the laws to more persons conspired by force, intimidation. So if they do it physically or not, they owe you money. And if you're injured, so-and-so, provision of rights and the conspiracy of the same. So any questions so far? Oh yeah, definitely. That's the reason why you use it, because that sets things up for a lot of things. And that's one of the enforcement. And we haven't even gone into the Burning Convention Act itself that shows you the list of liabilities for anyone who violates it. But that's that for now. But you got it. You got it. Yep. And don't forget the Constitution. Yeah, it does. And I said don't forget to bring in the Constitution also as a count. Yeah, the more we actually show the operation of it, it becomes streamlined and easy, and you begin to join the dots together. So all the videos being created is just as a prep for this to actually show you how it adds up. And again, if you're doing that fair depth pseudo fair collection, you can add that if you want to, but it's not necessary. It's just not necessary because remember, those Fair Debt Collection Practice Act have their own 50 USC 1692, 1681 that you will show within that suit itself. You can add these as assault to injury if you want, but it's not necessary. But for other matters, I highly suggest doing it this way. Okay, 1 second. Now, so far, all that we've mentioned is just jurisdiction. We're still on the note of jurisdiction and how jurisdiction intricately ties to all these things. Now, let's move on to venue. Verbiage where it says the key to venue is where it took place. So there are two main ways to which venue is determined. Venue is determined if it is the location of the defendant that you're filing the suit, or shall I say, you can file the suit where the defendant is located or where the violation took place. Now, where did I get that from? Right here. (28 USC 1391). Venue, generally. Applicability of section.
Complete 1 hour and 45-minute video of the entire meeting. It's been posted on the Patreon page. Take care. Best of luck.